Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
It was day 2 of the battle over Brexit Britain at the Supreme Court. On one side of the courtroom stood lawyers for the government making their final points. On the other, lawyers for the woman who started this fight, Gina Miller, insisting that she knew best. It delivered a day of divide over the big Brexit question of the moment. Can the government trigger Article 50 and begin the process of exiting the European Union without a vote in Parliament? Well, watching it all has been our legal commentator, Joshua Rosenberg. But let's begin with James Eadie QC, who put forward the government's closing arguments.
Firstly, the prerogative to make and unmake or withdraw from treaties exists today as a key part of our Constitution and as Parliament well knew in 1972 and well knows today. Parliament has quite deliberately chosen to regulate some parts of those prerogative powers. It's done so expressly and in detail, and it has not touched the prerogative power to give Article 50 notice again and evidently, quite deliberately. There is no basis, we submit, for the imposition of some form of hidden legislative presumption on Parliament's intention. The rights in question are those created on the international plane, and they're simply recognised by our law. Indeed, it's of the very essence of the 72 Act, if one focuses only on that EU rights created on that plane will be altered and removed directly through the exercise of prerogative powers. So, fourthly, we submit that the apparent simplicity of the position which the respondents put forward represents, we submit, a serious constitutional trap. The principle and its application in a context such as the present is at best highly controversial. That is not, we submit, a proper premise, a proper basis for a presumption as a tool for imputing intention to Parliament.
Well, let's dissect the legal arguments now with Joshua Rosenberg. What exactly was James Eadie saying there?
This is all about the meaning of the Act passed in 1972, which took the United Kingdom into what is now the European Union, and what it actually means. Now, that remark about a constitutional trap was aimed at Gina Miller's lawyers. She, of course, is the woman who brought this case, and her lawyers are saying, well, you can't take away rights granted by Parliament under the 1972 Act unless Parliament says so. Whereas James Eadie said there's no need for that. You can use the inherent powers of ministers, these prerogative powers that ministers have had. These powers make and unmake treaties, and they can be used to take the UK out of the EU in the same way as the government can use its powers to change other treaties.
Now, we've also heard today from government lawyers representing Northern Ireland and Scotland. Let's have a listen now to Lord Keane, who told the court that triggering Article 50 would not alter the essential structure of devolution.
So, in summary, my Lord, the devolved legislation actually takes the court nowhere in the determination of the issue, which it has to decide in the present case. There is no means by which you can suggest that the exercise of the foreign affairs prerogative, which is what we're actually here to address, is in any way impinged or qualified by the devolution legislation. My Lords, there is no dispute that the devolution statutes comprise very significant pieces of legislation, but nothing in the issue of Article 50 or its notification, or indeed withdrawal from the EU altogether, alters the existence of the devolved legislatures or the essential structure and architecture of the devolution settlements.
So, Joshua, what's the significance of what Lord Keane was saying?
Lord Keane is the Advocate General for Scotland. He is the UK government's advisor on Scots law. He's a member of the UK government. And what he's saying is that the devolution arrangements to Scotland, to Wales, to Northern Ireland don't cause any problems for the UK government in what they want to do. There are conventions that the UK government won't legislate for Scotland, Wales and Northern Ireland without the consent of the legislatures in those parts of the United Kingdom. He said they're only conventions, they're no more than a statement of intent, and Parliament in Westminster can go ahead with what the government wants to do, and indeed the government can go ahead without the need to get the consent of ththose legislatures.
So that's the end of the government's arguments. How receptive do you think the judges were?
I think they tested those arguments. They were quite firm in putting questions particularly to James Eadie. I don't know whether they're persuaded of him. He has an uphill battle because he's trying to persuade them that their colleagues in the High Court were wrong. But, he put his case firmly and clearly and said, surely the government has these powers and this is what was always intended.
Have to wait and see what the verdict is. Now, the woman who brought the case against the government is Gina Miller, who is the main respondent. You can have a look at some pictures of her here arriving at court. And Joshua, it's quite incredible, really, to think that she has taken on the government in this historic case. It's
a brave thing. You see the two men on either side of her. There's her security. She's followed by her lawyers, but she's had quite a lot of death threats, I'm afraid, in just bringing this case, which she says is simply to establish what the law says. But she did indeed get her say. She doesn't, of course, give evidence, but we did hear from her lawyer, Lord Pannick.
Well, funny you should mention that. Let's have a listen to Lord Pannick, shall we? This was his opening argument.
In any event, we say, Parliament did not intend that the rights and duties which it had created by the 1972 Act could be nullified by ministers acting on the international plane. My Lords and my Lady, I say at the outset that the courts have rightly recognised that the 1972 Act has a constitutional status. It creates a new source of domestic law, and indeed it gives priority to it. The appellant's argument, however, if correct, would mean that the 1972 Act, far from having a constitutional status, would have a lesser status than any other act, a lesser status than the Dangerous Dogs Act, because on the appellant's argument, Parliament has made this fundamental constitutional change to domestic law only for as long as the executive does not take action on the international plane to terminate the treaty commitments.
So Lord Pannick there saying that the government's argument gives the 1972 Act less significance than the Dangerous Dogs Act. What exactly does he mean by that?
Lord Pannick's point is that James Eadie, if he's right, is saying that the 1972 Act can be overridden by ministers using these prerogative powers, and the 1972 Act will simply carry into effect in English law, the law of the United Kingdom, what ministers have decided. So if ministers pull out of the treaties, the 1972 Act will simply act as a conduit, as a pipe, and give effect to that. And that would mean that this Act was, less strong than any Act you mentioned. He mentioned the Dangerous Dogs Act. On the contrary, he says, this is a constitutional Act because uniquely in our system, it says that other subsequent law is going to be trumped by the 1972 Act. If the law is changed, well, the 1972 Act bringing in EU law will take priority over subsequent law that is inconsistent. So far from being something that you can get rid of effectively by ministerial decision, it's something that's much stronger than any other Act of Parliament, he says.
Very colourful argument there. It's worth listening to a bit more of what Lord Pannick was saying. This is what he described as a crucial point in the case. Ministerial prerogative powers can't override an Act of Parliament. Let's have a listen to what he said.
And the prerogative power in relation to treaties is not an independent and overarching power. It is a power which is defined and limited by the other principles of our constitutional law, in particular parliamentary sovereignty. And these propositions that the power in relation to treaties is limited by the inability of the prerogative to change domestic law are supported by high judicial authority. the court will have seen, and I won't go back to it unless I'm asked to do so, Lord Oliver's statement for the Appellate Committee in J.H. Rayner. And Lord Hoffman there speaks of it being the corollary, that's his word, the corollary of the unrestricted treaty-making power, that it cannot change the law of the land. And my criticism, my respectful criticism of the appellant's submissions, is that they emphasise the scope of the prerogative power in the context of treaties, but they seek to avoid what Lord Hoffman described as the corollary, that the power ends where domestic law rights begin.
So Lord Pannick did say that there aren't many cases that he could find of ministers trying to get around an Act of Parliament.
That's right. And he was talking about high judicial authority, which is legal speak for decided cases. We are, after all, talking about the development of the common law, so you look back at how the courts have dealt with these points in the past. And there weren't many cases, as you say, where ministers have tried to override the effect of an Act of Parliament. And he's saying that the courts have decided that this is not something that ministers should be allowed to do. It's something simply that the law does not permit. He says that ministers can use their prerogative powers to conduct treaties, but once you get to this clash between ministerial powers and Parliament, Parliament wins, and ministerial powers stop when you get to the door of Parliament.
Now, there were certainly some combative exchanges again, Lord Carnwath leading the charge by focusing on how helpful the 1972 Act was to Lord Pannick's argument.
The United Kingdom could not leave the EU in 1973 or 1974. That's not the position.
No, but the question is whether it could do it by prerogative or whether it would have needed Act of Parliament. And I've no doubt that if it happened in 1973, there would have been a parliamentary debate, the government would have proceeded, there would have been negotiations. At the end of it all, there would have been an Act of Parliament.
And Article 50, in my submission, doesn't, the existence of Article 50 doesn't change the position as to prerogative power.
Well, we'll come to Article 50.
Well, can I just make the submission, Ron? The reason why, since your Lordship asked the question, the reason why Article 50 doesn't alter that is because we all agree that Article 50, although it gives a power to leave the EU, it refers to the constitutional requirements of the member state, and we all agree that that is a matter for domestic law. It doesn't alter that question.
Quite a robust exchange there.
It was. This goes back to this fundamental question of whether ministers can use their prerogative powers. And what Lord Pannick was saying was that shortly after the 1972 Act was passed, ministers couldn't use those powers to pull out of what became the EU. And if they couldn't do it then, they can't do it now. He's saying Article 50, the provision which is fairly recent, added by the Lisbon Treaty effectively, that doesn't make any difference. And this touches on this argument which we haven't really heard so far in court, which is whether giving notice under Article 50 is a one-way street, whether it can be revoked once granted. And what Lord Pannick was saying is that both he and the government have agreed that is not something they're going to talk about. This case is about the UK's constitutional law, what that requires, and the reason they don't want to talk about it is if there's any dispute over that, it would have to be referred to the Luxembourg court. That would take a long time, and that's something that nobody wants.
Interestingly enough, Lord Carnwath looked slightly frustrated. It's worth having a look at his reaction to the response there.
He did. I mean, it's interesting as to whether you can actually read into somebody's face what they were saying. He did actually stumble slightly himself, and he referred to Article 90. He meant Article 50. It's quite a stressful thing for both sides, both the judges and for the lawyers. And they're thinking aloud. They're testing out the arguments in this forensic arena.
And so many people watching their every move. Joshua, what's your final thought at the end of day two?
I think we saw a superb example of advocacy from Lord Pannick. If this was a football match and if you were trying to work out, who won, you would say that Lord Pannick had the better arguments just in the way he put his arguments. There were law tutors tweeting their students, watch this, just to show how to quote a case, how to read a quick summary of it, but how to be prepared to answer any questions on the meaning of it from any of the judges, as indeed happened. So he managed to do extremely well. I have to say, I know him very well. He's been a friend of mine for more than 30 years. He is an advocate at the top of his game, but there's no doubt that he managed to charm the judges. Whether he will persuade them through this charm of the strength of his argument is something we shall see.
Thank you, Joshua, for your thoughts on day 2 at the Supreme Court.
I've been getting away with it all.